Hello, my name is Sujit Kunan. Welcome to this tutorial on industrial disasters and the environment. In today's tutorial, we are discussing industries and its impacts on people and environment from a legal perspective, that what kind of legal mechanism and legal system we have in India to address the implications of industries on people and environment. So, before we get into that, let us try to understand what is the context in which we are discussing industries and environment, or industrial disasters or accidents and environment. The specific context is the rapid industrialization, and of course, it is needless to say that industries affect people and environment, and in many cases in a drastic way, because the potential of it is needless to explain that the potential of industries to cause damages to people and environment. In this context, probably it is worthwhile to look at the Bhopal gas leak disaster in 1984, and this can be considered as an eye opener in the Indian context when we discuss industrial accidents and its implications on people and environment. And the Bhopal gas leak disaster 1984, it demonstrated apparently in a negative way that what can be the magnitude of such an industrial accidents on people and environment. So, these wider impacts, I mean the implications or the magnitude of the implication is such that it changes or it continues to exist even in different place and different time. For example, even after 30 years, almost 30 years, and people and environment in the surrounding areas in Bhopal, they continue to suffer, they continue to face the problems. And many of these problems was apparently difficult to imagine or difficult to predict in 1984 or in the subsequent years when the matter was decided by the court. So, when we look at this issue from a legal perspective, that we need to consider two important issues. One important issue from the legal perspective is how to prevent such industrial accidents. What kind of legal mechanism we have to prevent industrial accidents from happening. And the second important legal issue or issue from a legal perspective is the liability, because we may have several legal mechanisms in place to prevent such industrial accidents, but still the risk continues. So, there is always a risk, and there are chances that the risk can materialize and results into industrial accidents. So, what happens when such things occur? Well, there could be another scenario where industries might have followed almost all relevant rules, or industries' actions could have been perfectly within the legal limits. Still, there could be risk, and there is possibility that the risk materializes and it results into industrial disasters of different magnitudes. So, in such situations, probably the legal answer or the answer from a legal point of view is liability. So, in this module, we will be focusing overwhelmingly on this issue of liability. So, specifically we will be discussing what kind of legal mechanism we have in India to address this issue, how to fix liability, of whose liability, and what is the nature and scope of the liability. Before we get into the liability issues, might as well it is better to spend a little time to understand the liabilities industries in its historical context, because liability of industries in the context of environment is not a new phenomenon, or maybe I mean in the context of environment it is a new phenomenon, but liability of industries per se is not a new phenomenon. For example, industries were, I mean, even in the history, even starting from the early 20th century onwards, industries were held legally liable for various actions. However, the problem was that the scope of such liability was quite narrow. Industries were held liable for whatever happens within the premises of the industry, or industries were also held legally liable for all injuries caused to employees. So, what we can say is that the focus of liability was quite narrow, and its scope was limited to the industrial premises as well plus employees working in the industry. So, to put it in a different way, I mean the liability of industry was not extended to the outside environment, but at the same time the incidents like Bhopal gas leak disaster that proved that industries can cause serious implications on environment and people living outside or environment outside the industrial premises. But this narrow focus was apparently the predominant approach in the early 20th century. Say for example, if we look at Workmen's Compensation Act 1923, and this talks about compensation to be given for the liability of the industries to provide compensation to workmen or the employees for injuries caused in the course of employment. Similarly, a similar kind of approach was also adopted under the Factories Act 1948 as well. But however, the key question is, when did this focus expand? Under what circumstance or what circumstances that prompted the legal system to expand the scope of liability? It is needless to explain that the environmental consciousness that provided the important rationale or the context in which the scope of liability was expanded. For example, in the later half of the 20th century, we knew quite a bit about the implications of industries on a wider scale, and probably many industrial disasters such as the Bhopal disaster 1984, oleum gas leak disaster incident in 1985, if we take examples from India, or if we take examples from elsewhere in the world, for example Chernobyl in 1986. All these, in addition to many other oil leakage incidents, oil leak from ships. So many of these incidents that demonstrated clearly the wider impacts of industrial accidents on people and environment outside the industrial premises. Apparently, this prompted the legal system both at the international level as well as in India to respond to this issue. One of the ways in which the legal system responded was by expanding the scope of liability. So early responses in this regard could be seen in environmental laws. For example, when we look at early environmental laws like Water Act 1974 or the Air Prevention and Control of Pollution Act 1981, and if we look at these laws adopted a different kind of approach as far as industries vis-a-vis environment is concerned. For example, these laws, whether it is Water Act 74 or Air Act 1981, these laws prescribe an administrative mechanism to design some permissible limit for industries. And it also designed an institutional mechanism to monitor that industries are working within the prescribed limit, within the limit prescribed by the law. In many cases, they focused on pollutions and prescribed permissible limits for pollutants, and the industries were expected to work within this limit. So as long as they work within this limit, there is no question of legal liability arises. But when we look at this, these laws, an important dimension that comes from these laws is like the focus of these laws were mainly on prevention of any kind of industrial accidents or prevention of implications on environment. But the question is, as we already have discussed, there are chances that even after following all these laws or even after working within the parameters prescribed by the law, industrial disaster or accidents can happen. So what happens when such incidents occur? And probably the answer from a legal point of view is liability. When we discuss liability, we need to also understand from where it originated, under what circumstances this idea of liability was originated. The idea of liability or the concept of liability was originated in the English legal system through a branch of law called tort laws. And there are different kind of liabilities evolved at various point of time. And when we look at liability, it is premised upon this basic principle that no person can cause injury to any other person. If any person causes injury to any other person, that results into legal liability. So in this case, what we are essentially leading to this concept called fault based liability. That means in order to establish liability or in order to determine liability, the liability should be preceded by fault. Fault in this context, in the context of tort law or specifically in the context of negligence, it means breach of a legal duty. When we say breach of a legal duty, it could be It could be a duty to do something, or it could be also a duty to abstain from doing something, whether it is a positive duty or a duty to abstain from doing something. If there is a violation or if there is a breach of legal duty, and then that results into damages or injuries, and this injury or directly or automatically leads to liability to provide remedies. So, this fault based liability has been the dominant rule on liability in the civil law context. But however, I mean, when the time passes, I mean, this fault based liability proved to be inadequate to address many situations, and this is the context in which the English court evolved a new principle on liability, a new form of liability called strict liability. Strict liability was first introduced by a 19th century English court in a case called Rylance versus Fletcher. And in this case, I mean, the court observed, or court introduced this principle of strict liability with the understanding that, I mean, fault liability is inadequate. There could be many situations where where industries or individuals do not commit any mistakes, still their processes or their activity can cause injury or damages to people and property in the neighborhood. So, the idea behind the strict liability was to fix or determine liability even in such cases. This means to fix liability even in the absence of negligence or fault. Or to put it in a different way, the idea behind the strict liability was to cover exceptional circumstances where accidents occur even though or despite the adequate care taken by the concerned person, or in the context of industries by the concerned industries.